What happens when a person gets 3 DUIs? Well, in Indiana, that's a tough question. So, first DUI, typically seen as, hey, it could happen to anybody. You made a mistake, learn from it. The second DUI in Indiana, judges and prosecutors are understandably a little upset. Hey, you're not learning from your mistakes. But typically, there is some grace because, hey, you know what? Maybe the person didn't realize how serious this was. Maybe the person is battling an addiction issue. So there is still some grace with the second DUI. It's so much more serious than the first. But officers, judges, prosecutors understand alcohol can be an addicting substance for some people. The problem is with the third one, most judges and most prosecutors are going to be like, hey, what's it going to take for you to kill someone? And so that's the battle you're facing when you have a third DUI. It's an uphill battle. So just understand, everyone's going to be mad at the person who gets a third DUI. That's the fact. You have to accept that. And I'm not saying you have to be happy about it, but accepting is the first part of responding. And so now it's the person who has 3 DUIs, it's their job to show the prosecutor, show the judge that they are learning their lesson. And Indiana legislature has made laws to severely punish individuals with 3 DUIs. The first of which is mandatory jail time. If somebody is facing their third DUI, there's a mandatory jail days of 10. And that's the minimum, that's the floor. And most places want much more than the floor. But even worse than the mandatory jail time is the fact that if the third DUI is within 7 years of the second DUI, then that third DUI is going to be charged as a level 6 felony. The maximum time in jail for a level 6 felony is 2.5 years. Now, 2.5 years may not seem terrible, and it is terrible, but it may not seem to some people, well, that's it. But the problem is there's something else called the habitual vehicular substance offender, and that is terrible. The habitual vehicular substance offender basically says if a person has 3 DUIs and the second DUI is within 10 years of the third DUI, well, the prosecutors can file this habitual vehicular substance offender provision, and the habitual vehicular substance offender adds up to 8 years to the underlying DUI. So if a person has spaced out their DUIs so far, and it's more than 7 years since the last one, then it's still a misdemeanor, which is awesome. But a normal misdemeanor is punishable by 1 year. A third DUI with the habitual vehicular substance offender, well, that's punishable up to 9 years. 8 plus 1, 9 years for a misdemeanor. That's insane, right? If it's a felony, typical level 6 felony, well, all of a sudden, 2.5 plus 8 equals 10.5. That gets pretty crazy. A person's probably thinking to themselves, well, there's no way I'm going to go to jail 10.5 years for my third DUI. And that person is probably right. But recent Indiana Court of Appeals decisions have affirmed 6 years for a person's third DUI when there was an accident, plus the person was kind of mean to the police officer when they found them. So courts are coming down more and more in favor of longer jail sentences for habitual vehicular substance offenders. And I tell that to anybody watching this video, not to scare them, but to incite action. Anyone facing a third DUI needs to do things now to help minimize the chances of them going to jail for 10.5 years, 5.5 years, 16.5 years. And that all starts with calling an attorney who regularly deals with DUIs. My practice from my law firm and my partners is anyone on their third DUI. That's a high priority client. All my clients are high priority. We love them all. But a third DUI, we understand that lots at stake. So the first order of business is to get that person into a county-approved drug and alcohol program. I'm not saying you have to check yourself into a facility, but we have to get a person assessed for drug and alcohol issues. That's number one. Number two, reach out to the prosecutor immediately. Hey, I'm sending you this. I'm representing this guy. I want you to know he's not going to be trouble, and we're going to try to work this out so that he gets his treatment and he gets his underlying issue taken care of. Now, we do that not because we're waving the white flag and we're giving up, but we want the prosecutor to understand, hey, if you're going to file the habitual vehicular substance offender, hold off for a second. Now, some counties like Marion County don't file the habitual vehicular substance offender enhancement until negotiations have broken down. Some counties like Hamilton County will file it immediately. Some counties will just do it on an as-needed basis depending on the prosecutor. But the reality is, with so much time at stake, it's imperative for the attorney to reach out to the prosecutor and try to, if they can, avoid having the prosecutor file that. This habitual vehicular substance offender provision is devastating to most individuals. Some judges take the impression that it has to be executed. You can't do probation. Now, I don't personally believe that's the law, but I'm not a judge. But we have to take immediate action when somebody comes into our office and they have a third DUI, because 10 and a half years, that's a lot of time. And most people do not want to be in jail. They want to be out of jail, working, taking care of their families and their other responsibilities. So a third DUI is about as serious as it gets. If you have any questions about DUI law in Indiana, give me a call, 317-632-3642. I love talking about DUI defense. In fact, I'll probably do it all day. But most importantly, remember to always plead the fifth.